What are we doing?
Your Honor, I was just going to ask for a short adjournment here. Just going to look in to see if we can get him. Sorry, I don't know why I always say here.
I don't either. I don't know. Because I guess you asked for adjournments there too.
Yeah.
All right.
Yeah, I need to request an adjournment just to see if I can get him into
May 16th, 2024 without objection.
May the people consider that bond?
You may.
Thank you. Your Honor, at the time the defendant was arraigned, he requested a $50,000 surety bond, and that rate, the defendant, $50,000 surety bond was 10%. I think that I'm asking the court to review that for an abuse of discretion. This is the defendant's 11th or 12th OWI that we can see. His priors are from 2020, 2018. There were two in 2012. 2005, 1995, 1993, 1992, 1989, 1988, and 1986. And specifically, he got for OWI.
What year?
2022. The concern for people is the rest of the public and the defendant. Master plays on the scrum cutter and there's been no indications that he's violated.
All right, guys, let's be real. This isn't a movie. It's a courtroom. The defense came in shaky, just trying to buy time. But time doesn't fix broken promises. Not today. This judge isn't here to play games. Delays won't save anyone now.
This morning, but this pervasive and ongoing history of OWI is of extreme concern to the people, the safety of the public.
Your response.
Oh, Your Honor, Mr. Radke is a Navy veteran, disabled veteran from 1982 to 1985 with an honorable discharge. He's Michigan born and raised. He resides in Wayne. He regularly attends AA meetings. Last time he attended an AA meeting was yesterday, and he attended 2 of them. He also let me know that he voluntarily has looked into checking into an inpatient treatment program in Detroit. I believe it's called Life Challenge Inpatient Treatment Program. It is Christian-based, and he let me know
How
that.
come he isn't in an inpatient treatment program now?
Your Honor, he has been going to AA meetings, and it's an up and down battle with Mr. Radke. And
I understand that, but I also understand that he served prison time for drunk driving. Was released in 2022. And by 2024, I'm back here again with this.
Let's be real. This guy's record. It's long and rough going all the way back to 1986. One DUI after another. People gave him chances, and he blew every single one. You can feel it in the courtroom. Everyone's thinking the same thing. Enough is enough.
Right?
yeah, that's correct, Your Honor.
What was the alleged BAC in this matter?
Yeah, that's a really good question. We're still awaiting the blood results. This was a single vehicle crash that occurred. The defendant.
There was an accident?
Yeah, he crashed, a single vehicle crash. And the defendant
Mr. Allen.
released all field sobriety tests, all PBTs, and the blood, as the blood draw as well, and we did get a warrant. So we're still waiting on that, but we did charge the case given the history. And I will let the court know too that at the time that the defendant was booked into the Washtenaw County Jail while awaiting medical examination, he did submit to a PBT at the jail, which was a .147.
That was at the time, 147 at the time of booking?
At booking, that's right, Your Honor. But of course, the court knows we won't be able to use that number for our case, but that was the PBT at the time of booking.
Anything else, counsel?
Your Honor, Mr. Radke was arraigned in front of the Honorable Magistrate Fink. I believe she appropriately set the bond here at $50,000, 10%, with a scram tether, with a no drinking, no driving standard bond conditions. Yes, there was an accident. Nobody was physically injured. He has been on scram.
We had a blessing.
He had a blessing, but nobody, from what the alleged report says, nobody was injured.
Say, mention AA meetings, say he's a veteran, say he's trying to turn things around. He promises to check into rehab. But let's be honest, actions matter more than words. Why wait until now? Why after the crash? His blood alcohol level was through the roof. Someone could have been killed.
Then he checked in today early at community corrections His agent is Mr. Levitt. They downloaded they gave him a main base device for his home so he can continually test at home. He has had no issues since he's been arraigned. He is compliant with all of the bond conditions here. And he's
Counsel,
here.
you say that to me, but we're a week out from arraignment. It's a week.
I know, Your Honor, but I'm just trying to.
No, go ahead. You make your argument.
Yeah, I mean, I'm just trying to let the court know that Magistrate Fink heard both arguments. I believe she set the bond at an appropriate bond. If Mr. Radke would have known that the bond would be raised, he would have never posted a $5,000 bond that he had to use on his credit card. His son, he had to call his son here. His son is in the courtroom now, trying to take care of these matters. I'm just asking this court if it would have any leniency for Mr. Radke to allow him to continue to do what he's been doing and get these matters taken care of here.
I believe that given the defendant's record in this matter, given the fact that we don't have the test back, but he was almost a 0.15 at the time that he was booked in.
He got out of prison in 2022 and now, just 2 years later, he's back. Same road, same drinking, same danger. The defense argues that no one got hurt this time. But what about next time? Next time could mean someone ends up in a body bag.
Further, that there is an accident that has occurred. Also, given the defendant's record that he had just come off parole, basically in 2022, we're back in 2024. He's done this again. This is not by any stretch of the imagination necessarily an attempt to punish the defendant, but I believe that the defendant, he may be trying his best to do what he's doing, but what he's doing right now gives the court serious concerns or pause. I don't believe that the magistrate in setting the bond, I think that there has been an abuse of discretion. I'm going to set the defendant's bond in the amount of $50,000 cash or surety bond, no 10%. I will, however, do this. Make a decision. You said that the money was paid on a credit card. Okay. I don't have a problem refunding the bond that he's paid if he needs those funds to pay for inpatient treatment. So he can be released to inpatient treatment. I'm phrasing it that I'll consider release to inpatient treatment. I'm not saying on a PR at this.
His own son bailed him out $5,000 on credit. The defense is begging for mercy, but this isn't about sympathy. It's about public safety. His bond was fair, and his excuses. We've all heard them before. The court's job is to prevent the next disaster, not wait for it to happen.
He needs those funds, and you let us know that he needs those funds to get himself into inpatient treatment. I'm not going to have a problem with that. I want him to have help. I want him to not deal with it. I want him to be able to deal with the demons that face him. And I don't want him here on an OWI causing death. And I think that I need to protect the community, and that's how I'm going to do it.
Okay, Your Honor. Can I ask to approach, please?
You may.
Thank you.
All right, record should reflect that we had a bench conference just in terms of the details. And again, so that I'm very clear on the record, I don't have a problem refunding what's been paid, provided that goes to inpatient treatment.
Okay.
All right. And so I just need you to arrange that, get with the prosecutor. You guys give me an order and I'll sign off on it. Make sure if there's a cost to the inpatient treatment and you want the bond returned for the payment of that, make sure that portion is contained within the order.
Yes, Your Honor.
All right.
Thank you.
Thank you. Defendant is remained.
The judge lays it down $50,000 cash bond. No discounts, no second chances, but there's still one way out. Rehab. If that money gets him into treatment, he's allowed to go. The court doesn't want him locked up forever. They want him sober before someone ends up dead.